Thanks everyone for joining us. Welcome to the Marsh Workers' Compensation Center of Excellence webcast. Our moderator for today is Christine Williams. Chris, please go ahead.
Thanks, Liz. Good morning, good afternoon to everybody. Hello, and thank you for joining us today. I'm Christine Williams, a Managing Director in Marsh's Workers' Compensation Center of Excellence. I'd like to welcome you to our continuing webcast series on managing workers' compensation. Today, we're going to review employers' liability component of workers' compensation coverage. We'll look at employers' liability, particularly in the context of the COVID-19 pandemic. And as time permits, we'll answer as many of your questions as we can. Many of the questions that we received with your registration forms was more general about workers' compensation and COVID-19, things like the overall impact to the workers' compensation market, claims trends both for non-COVID claims and COVID claims, compensability, changes in state presumption laws, impacts of remote work, and others. While we won't be really covering those topics today, we do have a lot of information on them and more really related to the pandemic on our website, marsh.com, including some of the articles that you see here. Following this webcast, we will be sharing a copy of the presentation, which includes links to all of these and other workers' compensation thought leadership. You can also feel free to reach out to me or my colleague, Dennis Tierney, for more information. We will be sharing the replay instructions and the slides within the next week or so. With that, I'd like to introduce you to our panel today. I'm joined by Dennis Tierney, Marsh's National Director of Workers' Compensation Claims, Thomas Richard. Tom is founding partner for RTGR Law in Oakland, California. Jason Heller, partner at Goldberg Segalla in Baltimore, Maryland, and Jason Perlman, partner at Hennessy and Roach in Chicago, Illinois. We'll hear from our legal panel shortly, but first, Dennis, let's turn to you. Many experienced risk managers and workers' comp professionals have limited experience dealing with employers' liability claims. And certainly since this pandemic began, we've been hearing much more about it. With this increase in the discussion of these types of issues, what are some of the insights that you've been sharing with clients?
Yeah, thanks, Chris. So yeah, I can confirm there's been a lot of discussion, questions, and really some concern around employers' liability during this pandemic. And I think it really centers around a few things, right? I think first off, it just the exposure and the risk. We have some clients that had workers work through the pandemic since the start. We've had others that started working, once their offices or facilities have reopened. But the concern is, when someone is working, there is a potential exposure to them contracting COVID. And if it, is within the course and scope of employment, and someone were to get a serious injury, there is the risk that either themselves or maybe even a family member could bring a claim, directly against an employer outside of the workers' comp system. So I think it really centers around just that exposure and that risk. The other thing too is just, I think around employers' liability and employers' liability claims is a big unknown, right? We don't really see this exposure, this line of coverage come into play too much. I mean, there are claims. I mean, we know it's, we could find it on coverage B of our workers' comp policy, but we really haven't seen a whole lot of claims, at least in my experience in speaking to clients. So hopefully we can answer some of these unknowns in our WebEx today.
Thanks, Dennis. Now we'll take a look maybe at the most common types of employers' liability claims. Jason Heller, let's start with you, and then we can hear from Jason Perlman and Tom.
Thank you, Christine. Hello, everybody. So one of the first types of employers' liability claims are called third-party overactions. And it's essentially, although an employee is often limited to workers' compensation benefits as that quote-unquote exclusive remedy for an injury at work, an employee can sue a third party for contributing to that injury, essentially alleging that that third party was negligent. So in that scenario, if there is a contractual relationship between that third party and the employee's employer, theoretically that liability could be passed back to the employer, or the employer could even be enjoined in that third party lawsuit. So in that case, that's when that employer would want to rely on that employer's liability policy. The The second type we want to talk about is loss of consortium. So basically, if an employee suffered a serious bodily injury and now has some type of debilitating illness or even unfortunately died in an accident, a spouse could pursue a loss of consortium claim seeking punitive damages against the employer if that employer was found to be negligent. When we're talking about loss of consortium, we're essentially saying a loss of marital relations or companionship. And at this point, I'm going to turn it over to Jason Perlman to talk about dual capacity suits.
Thank you, Jason. The dual capacity suits are brought on by an employee against the employer when the injury arises from a product the employer manufactures. Here in these cases, the employer could be liable as both the employer and the manufacturer. We're not seeing these type of claims necessarily with COVID, but the next type of claims we want to talk about are a little bit more prevalent. The consequential bodily injury claim. The consequential bodily injury claim our lawsuits are filed by a family member for injuries that are alleged to be caused by that family member as a consequence of the employee's injuries. These claims have come up with COVID, and we will be talking about some of those lawsuits. Tom will now discuss fraudulent concealment.
Thank you, Jason. So in California and elsewhere, there's a concept of fraudulent concealment, which is a method to get around the exclusive remedy rule and for an injured employee to sue their employer and for family members to use as a vehicle for their own lawsuits against that employer. Fraudulent concealment of injury involves an allegation that the employer concealed from the employee the existence of the injury itself or its connection to the employment. And classic cases of fraudulent concealment can involve things like asbestos, where it's alleged that, for example, the asbestos fibers were known to the employer but concealed, the presence was concealed from the employee in the course of their work. It may or may not be covered by coverage B in a policy, a fraudulent concealment claim, if the action that is alleged is found to be a willful act or an intentional act of the employer in concealing the injury or the connection to work. It could possibly be excluded from coverage B by virtue of the policy terms itself. The insurer probably still has a duty to defend the employer in a fraudulent concealment lawsuit until it is established that the concealment did occur as alleged and that it was the kind of willful or intentional conduct that's excluded by the policy or by statute. So fraudulent concealment claims probably have to be defended by coverage B, but may or may not be covered by coverage B.
Thanks, Tom. And Tom, let's start with you on our next topic.
Sure.
What are some of the types of allegations that lead to employers' liability claims?
Well, willful and wanton conduct is a concept that's been around for a while, and there's a case, California case that we visit often when we talk about this topic, and called Reagan's Vacuum Truck Service versus Beaver Insurance. And what happened, and that was a situation where the vacuum truck vendor sent their employee out to they have one of these vacuum trucks that suctions out whatever needs to be removed from a particular site. And in this case, they sent the employee and his truck out to a Chevron facility, and there was petroleum byproduct that was being removed. And the fumes of the petroleum byproduct in the course of that work injured the employee. And this was not the kind of thing that normally was removed from that truck, or at least that's what's alleged. And the employee claimed that the failure to warn and failure to provide, the employer's failure to warn and failure to provide adequate protective gear and measures was a willful and wanton act of the employer in that case. So that's an example of a kind of case where willful and wanton is raised. It's interesting in the context of COVID-19, where we look at that case and the fumes that were injurious in that situation are somewhat akin to the virus of COVID-19 in the sense that they're invisible. It's not something that can be seen by the employee or the average person until until it affects you or until you're in its presence. And arguably COVID-19 is omnipresent in our society, and whereas toxic fumes are, fairly isolated to certain areas. So willful and wanton claims of this nature may in fact be more likely to come about if in the presence of COVID-19 because of the prevalence of it, its omnipresence, if you will. So I'll turn it over to Jason to talk about gross negligence.
Thank you. Gross negligence is a higher standard than ordinary negligence. Typically, it's defined as a course of action which shows an utter indifference to or a conscious disregard for a person's own safety and the safety of others. Some Illinois decisions equate gross negligence to recklessness, while others define it as nothing more than very great negligence. For the COVID-19 cases that we have seen being filed, this will be an interesting fact pattern because to allege something greater than ordinary negligence is how in most jurisdictions you're going to get around bringing the cause of action against your employer. Ordinary negligence claims would typically not stand, so most of the legal actions that we're seeing across the nation allege some higher standard, but it is a tough burden to meet. The next type of cause of action is intentional acts. This is defined as not an accident. It goes to the mental state. It will be fact specific, of course. The more significant issue for an intentional claim could be coverage. Most liability policies have exclusions for intentional acts. It is an interesting interplay as COVID litigation from employees has pled a higher standard. Will that negate potential coverage for some of our clients? The claims we are talking about today work through the interplay between workers' compensation, the B-side Part 2 or employer liability claims, and potential general liability policies. Now Jason will talk about reckless disregard.
Thank you. So when we're talking about reckless disregard, where essentially it comes down to when an employer exhibits a reckless disregard for the safety of others, such as a failure after knowledge of an impending danger to exercise ordinary care to prevent the danger, or if there's a failure to discover the danger through recklessness or carelessness when it could have been discovered through ordinary care. One of the other types of allegations we see is this intent to cause harm. And just as a fun fact, this is one of the 2 exceptions only in Maryland to the exclusive remedy rule. And this essentially, it's not common, but it's when an employer engages in conduct with the desire to bring about consequences of the act and harm its employees. So this isn't a negligence standard. This is more so an employee proving that there was a specific intent, that the action was done with the intent to cause that employee harm. It's pretty narrow and you don't see it very often, but it is one of the allegations. It's prevalent with these employers' liability claims.
Thanks. And Dennis, how does this translate into the possibility of EL claims related to COVID-19?
Yeah, Chris. So one point I want to clarify before I move on to that. I mean, one question that comes up a lot is regarding employers' liability and whether or not it's jurisdictional, right? And the answer to that is yes, right? Just we all know workers' comp is jurisdictional and employers' liability is jurisdictional as well. Each state has their own nuances, and as some of the other panelists mentioned, there's some of the things you have to prove. But I just wanted to clarify that point before I move on. So when we're looking at, COVID-19 and EL claims, there's certain allegations that we've seen on some of the lawsuits that have actually been filed, and I'm sure the audience will recognize a lot of these. I mean, the first one really is lack of adequate PPE training and fitting, right? The ability of not providing that PPE to your staff and not having proper training on how to use that PPE correctly. Next is around social distancing, right? I mean, having a policy around social distancing, having markings on floors and signs on proper social distancing, things around that. Next one is failure to provide a safe workplace and telecommuting options, work from home. I know a lot of our clients, have gone to full work from home, but there might be some out there that still require in certain industries, employees to come in and work. So if there is, a lack of a potential to give that option to working from home and providing that safe workplace, that's another allegation that we've seen in EL COVID-related claims. Failure to follow federal, state, and local guidelines. It's another one that we see. Obviously, when clients ask us what can we do on certain things to mitigate, that's one of the things that we always recommend. And then when we talk about screening, right? Are you taking temperatures of employees, when they come in, things like that. And lastly, just failure to clean, sanitize workplaces. Are you properly cleaning and sanitizing? So these are the allegations that we've seen on, EL claims filed to date. I'm going to get into some of those claims shortly, but that's what we've seen so far.
Thanks, Dennis. In fact, there have been a number of lawsuits that are filed already. So we'll take a look at a few of those now. Many were filed by the families of essential workers or their spouses who contracted COVID-19 and some who unfortunately passed away. Jason Perlman, let's start with you. Evans v. Walmart was one of the early ones to be filed. Can you take us through that case?
Sure. The matter, Tony Evans, special administrator for the estate of Wandu Evans deceased, was filed against Walmart and other defendants. It's in the Circuit Court of Cook County in the state of Illinois. This was, in fact, one of the first meaningful litigation claims we saw, essentially filed by an employee against their employer. And that raised a lot of issues for our clients. This is a case that kind of brings to the forefront during the course of action throughout all of this. At no time do we really have a full quarantine. Cars were on the road, fast food service places were available, restaurants were open, and certainly grocery stores and retail places were open. So this is the claim that we've seen brought by the family members. So in the Walmart case, the family of a deceased employee brought a claim alleging willful and wanton conduct, and we discussed some of those standards earlier. In Illinois, to prevail on willful and wanton misconduct claims, the plaintiff must prove that the defendant intended to injure plaintiff and acted in reckless disregard for plaintiff's safety. Specific intent to cause harm or kill must be established. Even in the event if the alleged conduct goes beyond aggravated negligence and includes such elements as knowingly permitting a hazardous work condition to exist, knowingly ordering claimant to perform an extremely dangerous job, willfully failing to furnish a safe place to work, or even willfully and unlawfully violating a safety statute, this still falls short, typically based on the case law, of the kind of actual intention to injure that robs the injury of the accidental character. With the Walmart case, all eyes are going to kind of be watching the jurisdiction to see what the rulings are. Most recently, counsel on behalf of Walmart did file a motion to dismiss with arguments relating to and regarding exclusive remedy, further arguing that the matter should proceed at the Industrial Commission, which is in Illinois where the workers' compensation claims would proceed and not in the circuit court.
Thanks, Jason. Zuniga versus Safeway is another case, this time out of California. Tom, what can you tell us about that case?
So in this case, this was similar to the some of the facts that Jason was alleging in the Walmart case, in the sense that this was early on in the COVID-19 pandemic, and the real gist of this was the fraudulent concealment theory. That was what the widow Norma brought with regard to her deceased husband, who was an employee of Safeway in a distribution center. And he did contract COVID-19. As Jason mentioned in his discussion about the other case, this was early on. So there's no question that the employee outside of work was, as most people were, engaged in normal activity without as much social distancing, as much recognition of the transmission of the pandemic and ways to avoid it. And in the workplace at Safeway, in this particular workplace, there was a similar approach to COVID-19. And as a result, there was evidence that the family was able to bring to allege that the employer fraudulently concealed the injury or illness, or fraudulently concealed its connection to work. And what some of the things they specifically raised in that lawsuit was the fact that Safeway had a poster that they had posted in the workspace, which basically told employees that masks, gloves, and other personal protective measures were not recommended for use by employees. And again, let me say that again, not recommended. So this was early on, and that poster itself, there's an image of the poster in the complaint itself that was brought by the plaintiffs in that case. So that was something where they were saying that this poster is evidence of what the employees were being told at the time, and is evidence of the employer's intent to conceal the relationship to work. They also pointed out too, at the time, there were no measures in place to cleanse and sterilize the store or distribution center. They failed to implement and promote federal and state social distancing guidelines that were going into effect at the time. And of course, they didn't provide masks, gloves, and protective devices to their employees. And as I mentioned, even affirmatively stated in the poster that such protective equipment wasn't even necessary.
Thank you, Tom. Jason, let's go back to you for Kenno versus Tyson in Iowa.
Sure. So the matter is Jennifer Kenno, the estate of Pedro Kenno, and other family members versus Tyson Foods. And this case is out of the District Court of Johnson County in Iowa. The Tyson Foods suit stems from the concentrated COVID-19 outbreak that occurred at Tyson Foods' pork processing plant in Waterloo, Iowa. The estate of 3 deceased Tyson Food employees alleged that Tyson officials were aware the coronavirus was spreading at the plant, and therefore knowingly put its employees at risk by requiring them to come to work. And that Tyson officials deliberately lied to employees about the presence of the virus so that they would remain on the job. As we move through some of these cases, we're seeing an escalating scenario of fact patterns alleged against employers that may be indicating some sort of conscious disregard, some standard higher than ordinary negligence being met, an actual intent to cause harm. We will be closely following these jurisdictions to see what courts' determinations are regarding these claims. I think all employers out there who potentially face claims that could be brought by the employee through the Industrial Commission or the workers' compensation claims, as well as potentially in circuit courts across the country, are going to be watching how these cases turn. I think they're all going to be very jurisdictional specific. They're also going to be factual specific. I think the greater the alleged facts relate to sort of a conscious disregard and intent to cause harm, the better chance someone may have about sustaining a claim like that against their employer.
Thanks, Jason. There are a couple other cases also in Illinois. Agaldi v. Aurora Packing Company, which is a case related to the death of a spouse of an employee. What should we know about that one?
Sure. The estate of Esperanza Agaldi versus the Aurora Packaging Company is filed in the Circuit Court of Kane County in Illinois. This claim is brought by the daughter of her deceased mother, who died, alleging that her father contracted COVID at work and infected the mother. It creates a different spin, a slightly different fact pattern as far as who the claimant is. This type of claim historically has been referred to as take-home claims, which we have seen in asbestos litigation. At the beginning of the COVID outbreak, as we analyzed these issues, there was tremendous concern that COVID claims would somehow be likened to an asbestos claim. Beyond the exposure claim itself for the employees, the fact that employee family members potentially could bring a claim is another issue. There is concern on the part of the employers and carriers that these types of claims could cost significant amounts of money over time, and that's how it's been reported. Courts historically have been split on the issue of businesses having an obligation for individuals that had never been on the premises for an exposure claim. The causal connection claim is disputed. The causal connection claim is disputed and typically requires a strong causal connection chain linking the family member to the employee and then to the business and the business's alleged failure to adopt safety measures. These cases are going to go back to some of the issues we were discussing. What mitigation practices have the employers been following, whether they've been following the recommended guidelines at the time. Those are kind of the intertwine. I could just jump right in. The next case, it's a similar type of claim. It's Miriam Alvarez Reynosa the BurnShaffer Inc. This case is filed in the Circuit Court of Will County in Illinois. It's brought by the wife of Reynosa, who's suing her husband's employer, alleging that negligence by the company led to her contracting COVID. She alleges that she became infected while caring for her husband. Her husband was a parts assembler at the company, allegedly because of a failure of the company to clean work areas and ignoring when other employees stated they had COVID symptoms. The facts regarding the timing for infection, mitigation practices, and other potential causes for infection will be an issue for this claim, as well as all the other similar claims filed like this.
Thanks, Jason. Let's change gears a bit and talk about what our listeners can do to help mitigate the risk of having COVID-19 related EL claims. Jason Heller, why don't we start with you?
Thanks, Christine. I think this is pretty self-explanatory, but really these guidelines can change week to week, depending on the status of the COVID-19 and how the infection rates are going. But really employers should just be monitoring the situation each and every week and following your local guidelines, whether it be state or county or city, and allow that to dictate how your business can operate. As long as we're staying within those guidelines, it does offer a layer of protection to the employers. The other part of this would be also to consider enacting a work from home or telework policy. Obviously, there's not all professions can offer this accommodation to employees, but if you are in a field that allows people to work from home productively and they can accomplish their job remotely, enacting that home and telework policy again is going to offer that second, third layer of protection. It's going to reduce the population of employees in the employer's physical location. So obviously just everything we're going to be doing here is to mitigate risk. And that's a big thing that we can do to help with that. And at this point, I'm going to turn it over to Tom to talk about making modifications and adjustments.
So the modifications and adjustments are a lot of the elements we've covered in the cases that will keep us out of trouble. Putting up posters that give good information to employees about personal protective equipment, personal hygiene, steps that have to be taken. Posters where it's seen and obvious in the places where it needs to be. For example, near laboratories, in the break rooms, and so on. Training, company-wide training, and especially site-specific training for each individual location, cleaning and disinfecting measures. This goes to training and posters as to what the employee individually needs to be doing, but also what the company is doing with its staff, in addition to normal cleaning and custodial work. What extra measures is the company doing and can do? Informing others of positive cases is an important thing to adopt, and is going to be legally required in California on January 1st when AB 685 goes into effect. This is a law in California which puts some pretty onerous notice duties onto employers when there is a positive case in the workplace, even if the positive case is from a visitor or a vendor or someone else's employee, but in your workplace. there's duties on January 1st that the employer has with regard to notice. And of course, providing the adequate protective gear, masks, and so on to employees when they are working in that site. All of those are important for mitigating this exposure. But I think I would recommend going one step further, which is to document those efforts. So I'm advising a lot of my employers in their site, my clients in their site specific plans when they have that in place. Obviously save copies of those documents. If the document, the site specific plan and the training is acknowledged by the employee in some form, save that acknowledgement so it can be used later on as evidence if we need it. I'm asking my clients to go in and photograph their efforts. For example, if they're putting up protective shields between employees and customers, where they have posted the posters, photograph that. So we have that evidence now, and later on when we're defending that case in court, we've readily got that information available and can use it. And I'll turn it over to Jason to, oh, sorry, that's me covering waivers. Another step is releases and waivers. Where appropriate, there are obviously jurisdictional limits on how much an employee can waive or release in the context of workers' compensation in California. The answer is pretty much very little that an employee can waive, but employer waivers and releases that an employee signs vis-a-vis their family members in the context of a take-home claim, as Jason talked about, where that COVID infection is transmitted to family members or the community allegedly via work. Release and waiver may work in the context as maybe binding on those family members. And I would also mention in California, we have a very strong presumption law, COVID-19 presumption law, which makes it easier for employees or anyone bringing a lawsuit on behalf of that employee to allege that the COVID-19 was contracted by the employee at work via the presumption. And then the next step for that lawsuit to prove that the infected employee then transmitted the disease to the family members, really the only step the family member has to take in their lawsuit, because the presumption provides them with a legal fiction to get through the first hurdle or get over the first hurdle. So I would say that releases and waivers are worth considering in the context of these coverage B claims and general liability claims, certainly with regard to vendors, third parties, customers, visitors. Releases and waivers are potentially binding and very important and recommended. I had to sign a waiver to sit down and get my hair cut the other day. So it's expected by people. It's not unusual, and it makes a lot of sense. Yeah, and I'll turn it over to Jason to talk about evaluating court rulings.
For 7 to 8 months now, we've kind of all been in a bit of an unenviable position because we're being asked to answer questions that haven't been answered yet. When evaluating court rulings and subsequent legislation, we'd like to be able to provide some guidance as far as what the courts have done. We have to look toward historic precedent. We are working on and evaluating a truly novel legal issue. We will await court orders, rulings, and further government orders, which will impact our practice and the operation of the business for our clients we are retained to represent. Historic precedent regarding potentially similar claims and allegations will guide our analysis. But unfortunately, at this point, our analysis is limited just based on that. We're making recommendations to follow the rules that are out there across various jurisdictions, throughout the Midwest. If you cross one state border, there's completely different mitigation practices that are in place. How those claims will arise in the future, we anticipate that they will be coming. We've seen them initially on behalf of employees. What coverage is triggered, we're getting into the discussion on those issues. as it's been indicated, we certainly, the last section would recommend complying with the CDC and the World Health Organization recommendations. When addressing these claims, we will look at the timing of the claim, and at the time, the guidelines of the Centers for Disease Control and the World Health Organization, and also significantly the applicable state orders, local and jurisdictional orders from the courts on these issues, and await anticipated case law on these issues. It certainly will always be a recommendation to follow the best practices that are in place. Every time I go on a site inspection, I'm always impressed by the bunkers around certain pillars or the blaze orange around certain things. And it always impresses me that there clearly was a claim that happened here. With COVID, we have to wait and see what's going on. I fully anticipate that my colleagues and perhaps myself will be authoring the case law related to these issues in the future. Thank you.
And Jason, did you want to mention about the CDC and WHO?
Generally what I was saying is that there are recommendations that have been out that weren't the same as time has gone by. I think the key is to follow the recommendations as best you can. I don't think we could offer any distinct advice. In addition to CDC, World Health Organization recommendations, each local jurisdiction has had in place some recommendation as far as mitigation, best practices. If you're looking at a potential claim, we will have to factually analyze the moment the loss alleged to have taken place, what the recommendations were at that time, and what the level of compliance may have been. We're hearing different things from different jurisdictions regarding a disregard for what the best practices or recommendations were, and that potentially could create some exposure.
Thank you. So that's our main presentation today. If you'd like to submit a question, click on the Q&A on the bottom of your screen. If you prefer, you can email any questions about our presentation today to questions@marsh.com or to Dennis or me, and someone will reply after the webcast. So with that, let's turn to some of the questions that we've received. So Tom, why don't you take this first one? Is there liability under Part B when an underlying work comp claim has been denied? Or what is the impact of accepted claims when an EL suit is brought by a family member?
I think this is important in, as I mentioned, in the context of the statutory presumptions where they exist. Take-home claims or claims by family members historically have involved things like asbestos, where the family member comes home with asbestos fibers on their body. And, that's a fairly limited and narrow set of workers in the workforce, and a fairly specific kind of exposure, in the sense that, we're pretty sure that if a spouse of someone who works in an asbestos related facility historically develops asbestos disease, and that spouse had never been otherwise exposed, there's a fairly straight causal link between that exposure and that development of that disease. As the asbestos diseases are also very specific. But this is an omnipresent disease. In that context, it's everywhere. So it would be very difficult for, I think, someone to prove necessarily that that a claim under coverage B or employer liability for loss of consortium or one of these other allegations, except for these statutory presumptions, which make it much easier, because now the presumption has done the hard work for the plaintiff's attorney. I think this raises questions on coverage B, but it also raises questions on general liability, and it may raise questions on employment practices liability, insurance as well. All three of those policies can come into play with regard to COVID-19, because all three, you're dealing with the employee in the context of this pandemic, and if the employee is injured, or if the employee's exposure or the employee's reaction to the employer's alleged failure to mitigate or reaction to the employer's are having contracted the disease. For example, if an employee refuses to return to work for fear of exposure because of an employer's alleged failure to mitigate, and the employer takes a punitive action against the employee for that refusal to return to the workplace and insisting on an accommodation at home to work from home. Those raise employment questions, which all relate to the same set of topics that we've been talking about today, and that's where employer liability insurance could come into play. So all these policies, I think, are in the universe of this discussion.
Thank you. Jason Heller, can someone file both a workers' comp claim and an employer's liability claim concurrently?
Generally, an employee who's covered by state workers' compensation law can't file a comp claim and an employer liability claim concurrently. As we discussed before, workers' comp is often the exclusive remedy, with limited exceptions, among some of those being intentional injury, fraudulent concealment, and willful and wanton conduct. With that said, it doesn't mean that, like we spoke about before, that a spouse is precluded from filing an employer liability claim due to that loss of consortium type of issue.
Thank you. Jason Perlman, are there any jurisdictions where you're already seeing COVID cases coming out of the back end of the litigation process?
Not yet. The trend has not been to try to resolve voluntarily the potential high value claims that are out there, the fatality and other claims. It's unknown if some smaller claims perhaps are being resolved. The litigated matters are still in suit. Anticipated dispositive motions have been filed on issues of exclusive remedy and other issues related to those matters. The court's anticipated rulings will provide some guidance for counsel and our clients in the various jurisdictions, but to date, I'm not aware of any specific rulings that have disposed of any of the current active meaningful litigation for COVID claims.
Why don't we stay with you on the next one? We hit on this a little bit already, but this person says interested in potential liability if the employee infected at work goes home and infects a non-employee who becomes sick.
Yeah, so those are the claims we talked about earlier. They're typically referred to as consequential bodily injury claims. We have historically seen this in the context of asbestos claims, often referred to as take-home claims. Suits, as we discussed, have been filed. We wait rulings from the court. Asbestos, as an aside, is a lot different than COVID. The facts of a claim in terms of the claimant's behavior will certainly be at issue.
Great, thank you. Tom, what are the historical EL claims that would most closely compare to a COVID-related claim?
I think that in California, the case I think that was closest to me was the Willful and Wanton case, where that I mentioned earlier, Reagan's vacuum truck, the 1994 case, where the employee was exposed to toxic fumes and wasn't aware going into the job that there were toxic fumes that were going to be involved in his work that day. It was the byproduct of petroleum, and he was overcome by those fumes. And he filed a coverage B claim to get around the exclusive remedy rule. I can see, so that's how coverage B might be triggered has been in the past.
Thank you.
But then the take-home claim that COVID-19 is different because now the employee, instead of, he doesn't bring the toxic fume injury home. I mean, once you get exposed to toxic fumes, you don't necessarily become contagious with, well, you don't become contagious with and emit toxic fumes yourself, but someone who contracts COVID-19 in the workplace very much becomes contagious and very much can then transmit that injury to someone else.
Thank you. Dennis, one for you. What are the nuances state by state?
Yeah, thanks, Chris. I honestly could say I don't know the nuances for every state. I wish I did. I'd probably be a genius if I did, but I don't. But as we mentioned earlier, right, when we're talking about employers' liability, generally speaking, there has to be some sort of gross negligence. There has to be some intent to injure, and that's usually been a high bar. to prove pre-COVID with employers' liability. So we'll have to see how the courts rule with these specific COVID claims. But again, each state has their own nuance. For example, I know in Texas, in order for you to be an EL claim, there has to be a death, right? So again, I don't know the nuance to every state, but every state is different. And obviously, if there are questions, we could get jurisdictional experts involved to kind of give the ins and outs of each state specific law.
Okay. And let's stay with you for this next one, Dennis. How should we investigate COVID claims?
Great. So, first and foremost, if somebody is alleging a workplace exposure to COVID, our recommendation always to get that reported to your workers' comp claim provider, as they're the experts. Understand that they're going to have to rely on you too for some information. So with that being said, when we're investigating COVID claims, it really centers around three things, in my opinion. The first is symptoms, right? What are the symptoms? Are they consistent with COVID symptoms? When did they start? How long have they had them? The second thing is medical, right? Workers' comp is still based on medical evidence. There needs to be medical evidence in order for you to have a compensable claim. So is there a positive test of COVID? Is there a doctor giving a diagnosis and relates that to your job in your workplace? And the third thing is just exposure, right? I mean, when you're evaluating a claim, what's the exposure? Where has the employee been? Have they been to a hotbed where there's a lot of COVID cases? Do they take public transportation to work? Do they live with someone that might have the virus? Understandably that, there have been about 20 states or so that have made some law changes, which kind of could circumvent some of these. But I think if we stick to those three areas, I think it'll set a good framework for determining the compensability of a COVID claim.
Dennis, Jason Heller, what types of COVID claims should employers consider reporting under Part B?
So to kind of piggyback off of Dennis, I think it depends on which state you're in. And the first thing I would say is, if you have a concern, I would reach out to counsel in your local jurisdiction because they're going to be able to give the best guidance. But typically, if an employee is infected with COVID and the employer believes it could have been due to the employer's negligence in failing to comply with either state guidelines or CDC guidelines, the employer should consider reporting it under Part B of the policy. Same thing goes for if an employee's spouse or family member was infected. And again, if there's a consideration of negligence in there as well, it would be important to report under Part B, but that's not necessarily the case for every jurisdiction. Like I said before, Maryland, there actually has to be that intent to harm. So negligence isn't enough. So if we're just talking about negligence in Maryland, I wouldn't report it under Part B. This would be reported under, at least with respect to the employee, it would be reported under the workers' compensation, the first part of the policy. But again, it changes state by state. So that's really the answer. We need to look at state by state and how the states will view these.
Okay, thanks. Dennis, what are some significant issues that would continue beyond COVID-19 in the employer's liability space?
Yeah, so I think it's kind of yet to be determined, and this question, I think, as I mentioned, right, when we looked at employers' liability claims pre-COVID, a good portion of them were pushed back down by the courts back into the workers' comp system based on exclusive remedy. Now we have COVID-19, and obviously we're in uncharted territory, and we have all these family claims and different things kind of being brought about. So I think we just have to see, as some of the panelists said, see how some of the litigation kind of turns and what some of the decisions are, and if some of these decisions set precedent or not. And obviously, if one of these decisions may change the way employers' liability claims are looked at as we move forward, right? So that's why it's really important to track and see how these claims are going to be decided upon, because again, it could change the way we look at employers' liability claims, change the criteria, et cetera. So I think it's just, monitoring these decisions and see if it has any impact on how EL claims will be ruled on as we get past the pandemic, hopefully sooner rather than later.
Okay, thanks, Dennis. There was a question about waivers, which I think we covered already. Jason Perlman, can an employee employed under one legal entity file a COVID EL claim against another legal entity within one company?
This again is most likely going to be a jurisdictional specific issue. Practicing primarily in Illinois, The short answer would be indicated to be yes. Filing a claim and whether it could stand is certainly going to be the next issue. Just like with typical work comp claims, if the employer has multiple separate corporations, there then is the possibility of a work comp claim and a liability claim. The facts and relationship of each entity will guide if a liability claim can anticipate to be able to be stable and stand. Defense counsel would certainly try to have such a liability claim dismissed. We would anticipate the same thing under COVID, just like we would with any other typical claim where an employee is bringing his work comp cause of action and is suing a related or a similar corporation. But just like a corporation seeks to protect and not have its corporate veil pierced, the corporation cannot also typically claim all or multiple entities are the employer. These are factual and jurisdiction-specific issues for claims.
Okay, thank you. Jason Heller, do you expect COVID claim frequency to increase as cases rise in the U.S.? And I guess we'll say in the context of EL.
Maybe. We know that the COVID claims are going to rise. But yeah, I do think we can expect to see more of these claims within I would say both the workers' compensation and employer liability space. It's just going to be inevitable with all these cases that are coming up and people going back to work, being deemed essential employees. But again, I kind of harp on this before, but we're all about mitigating exposure, right? So if the employers, we need them to be proactive and to create a safe work environment and be consistent with CDC and its local state guidelines. And the more and more layers of protection you add that way, the better off it's going to be for the employers and the insurance companies.
Okay, thanks. Dennis, I guess this person's looking for some comments about requiring employees to quarantine after travel or visits from out of state or out of country visitors.
Yeah, I mean, I think my answer to this would be, just you need to follow what your federal, local, state, government requirements are, right? Certain states now are requiring that if you leave the state, you have to quarantine, you have to, some others, you have to get a test to, show that you're negative. So whatever guidelines are in place per your jurisdiction, my recommendation would be to follow those, because if you don't, as we mentioned earlier, that could open you up to some, potential accusations being made. So following, what's being required by your state and local governments, I think is the best advice I could give.
Okay, and I think we have time. One last question. Dennis, if someone contracts COVID outside the office and spreads it to others in the office, and under work comp law, it may be denied. So I'm guessing those that were exposed could bring an EL claim.
Yeah, so, well, I mean, first and foremost, I guess the first part of the question. So if somebody contracts COVID outside of the office and they come into the office and they're working with other employees, and those employees contracted the virus from that other employee, potentially that claim could be found to be compensable, right? Obviously, it's going to be based on the things I mentioned about doing an investigation. It's going to be based on the state law. But if someone's working within an office and another employee has a positive result, that does set up a potential basis for trying to get that being work related. Again, it doesn't mean it's absolute, but as the person put the question in, it can be denied, but it may not be as well. And again, an EL claim can be filed, right? I mean, as we mentioned, if every state is different, so it's kind of a high bar. So anyone can file anything, but in order for it to move forward and kind of go, you have to prove, that gross negligence and that intent to injure. So I think in this scenario, it pretty much might be hard to maybe pull through. But again, it's something to make sure that all the things that we spoke about are put into place regarding mitigation, because if someone does file EL claim, if you have those policies in place, that's only going to help you in your defense and mitigation of any types of these claims.
Thank you, Dennis. So I'd like to thank all of our panelists today: Dennis Tierney from Marsh, Tom Richard from RTGR Law, Jason Heller from Goldberg Segalla, and Jason Perlman from Hennessy and Roach. You've all provided us some great insights for our audience. Also like to thank all of you in the audience for joining us and participating in our discussion today. As I mentioned earlier, you'll receive a link to the replay of this webcast as well as access to the presentation slides. For any other information about our Workers' Comp Center of Excellence, please visit our website at marsh.com. For updates about Marsh's thought leadership offerings and other news, please follow us on Twitter at Marsh Global. And please reach out to your client executive or other Marsh representative for any questions or concerns you may have. We look forward to speaking with all of you again when our workers' compensation series returns in 2021. Thanks again for joining us, and we hope all of you stay safe and well. Thank you.